Today we shall look at the other aspect of a contract, the formation of a contract, which is what? Acceptance. Acceptance. We've looked at offer, we're now looking at acceptance. Now we shall look at the meaning of acceptance, the conditional acceptance, communication of acceptance, acceptance by post, and then revocation of acceptance. Now the meaning of acceptance is that it is an unconditional and final expression of willingness to contract with the offeror on the terms of the offer. Mind you, you know what is an offer, which is a proposal. Now, acceptance is a willingness, a final expression of willingness to what? To contract with the offeror on the terms of the offer. The offeror made an offer to you, and then the offeree is now willing to accept on the terms of the offeror. Now, intention to accept, mind you, is not an acceptance. You will make, the acceptance must be a willingness to accept in totality the terms that have been proposed to you by the offeror. So, if you are intending to accept, it is not an acceptance. Now, the accent of terms of an offer must be absolute and what? Unqualified, as I have said. For you to assent, to accept it, it must be what? Absolute and unqualified. Of course, we have so many cases to support this proposition. The case of INI versus Ferrando Agro Limited, it's a 1990 case, a Nigerian case, and then the case again of Orient Bank versus Bilante is also a Nigerian case. Goes to support the proposition that an offer must be final and the willingness must be so clear without any ambiguity. Now let us look at the elements of a valid acceptance. The elements of a valid acceptance. One, it must correspond with the offer. Two, it must be plain. Three, it must be unequivocal. Four, it must be unconditional. It must be without variance of any sort between it and the offer made to you, and it must be communicated to the offeror without unreasonable delay. Now, these are the elements of a valid acceptance. I said it must correspond with the offer, it must be plain, it must be unequivocal, it must be unconditional, it must be without variance of any sort between it and the offer, and finally it must be communicated without, to the offeror without unreasonable delay. We have plethora of cases to support the elements of a valid contract. We have the case of Oboika versus Benue Cement Company Limited. We have the case of INI versus Ferrando Agro Limited, which we've earlier on mentioned. And then we have the case of Hyde against Wrench. We have also mentioned it earlier on. Now, having looked at that, let us now look at the modes of acceptance. How do you accept an offer made to you? We have the following ways: by conduct, by your words, by documents exchanged. These are modes of acceptance. By conduct, by words, by documents are exchanged. All this goes to support the mode of acceptance of an offer. Now, does silence constitute acceptance? We earlier on said we have modes of acceptance, which we've itemized 3. But does silence, you just keep quiet, does that constitute an acceptance generally under the law. Following the case of Feldhaus versus Bindley, silence does not amount to an acceptance. Silence does not amount to an acceptance. And then the case we've said is Feldhaus versus Bindley. However, we have exceptions. The exceptions are where, number one, where the offeree expressly states that silence will be taken for acceptance. It falls within the exceptions. Where an offeree also improperly exercised dominion over goods sent to him for approval or inspection. It means he has accepted it because he has behaved in such a way that he has accepted it. So his silence will now constitute what? An acceptance. And then where both parties had a pre-existing relationship before the current contract, in that situation, it is deemed that a silence by one party constitute what? An acceptance. Now there are what we call conditional acceptance. Conditional acceptance. Let us look at conditional acceptance within the law of contract. This is an acceptance made subject to a condition. If you make an acceptance made subject to a condition, such a conditional acceptance is valid. Is invalid. Please take it again. Let's take it again. An acceptance made subject to a condition is invalid. So conditional acceptance generally is what? Invalid. Now they are of course subject to certain conditions, but generally bear in mind that conditional acceptance is no acceptance. Now there is an acceptance in ignorance of an offer, where somebody accept an offer and he is ignorant of that an offer, but he has accepted it in ignorance of the offer. Generally, an acceptance cannot be valid in ignorance of an offer. You must know that there is an offer before your acceptance will be valid. There are these reward cases where you may not be aware of an offer, you accept it or you do certain thing which in effect technically means you have accepted the offer. The case of Khalil versus Carbolic Smoke Ball Company is a point in issue. Now, the communication of an acceptance. Generally, acceptance must be communicated to the offeror before it can be valid. That is the position of the law. And then the method of acceptance will be orally, in writing, by conduct. These are, as I have earlier on mentioned, orally, in writing, or by conduct. However, as we've said, there could be exceptions. That's by way of waiver. Sometimes you don't need to say it by way of waiver, but by the conduct of the parties, it could mean there is a waiver that you don't need to communicate the acceptance by. But your action or what you have done will constitute an acceptance. In the case of, again, Khalil versus Carbolic Smoke Ball Company comes in mind. Now, the moment of acceptance, generally acceptance occurs when the offeror has notice of the acceptance. The notice need not come directly from the offeree. It could, and the acceptance can be in telex. I'm talking about telex of those days, face to face, on telephone, on telegram, and then now, as we've said, online. It could be via WhatsApp, Twitter, and all that modern communication gadgets. All this could be ways of communication of acceptance. And of course, it could be by prescribed method of acceptance. the parties will agree that this is how I want my acceptance to be. If you're accepting via this mode, the parties will agree that this is the mode of acceptance. Now, there is this peculiar case of acceptance by post. Mind you, before the advent of modern technology, online, this online system of communication, modern time, we used to go by way of post. So there is a rule laid down in Adams in versus Lindsley, where defendant offered to sell wool to plaintiff on September 2 by post. Plaintiff received letter of offer on September 5 due to wrong address. Mind you, all this was via the postal services. Now, plaintiff wrote a letter of acceptance and posted on September 5, and the letter reached the defendant on September 9. But the defendant expected an acceptance letter on September 7. As he didn't get it, he sold off the wool to a third party on September 8. So the rule is that if it is by post, it can also be by post. So once you send your acceptance by post, it is deemed to be valid as far as the ruling in Adams against Lindsley is concerned. Now, acceptance, we have exceptions to the acceptance by post, which are the terms of offer expressly request acceptance to reach the offeror. Now, inconvenience and absurdity, and then wrongly addressed or inadequately stamped letter, and then improperly posted letter of acceptance. Now let us look at the final aspect of acceptance, that is revocation of acceptance. Acceptance can be revoked at any time before it reaches the offeror. In acceptance by post, since the contract is formed at the point of posting the letter, revocation of acceptance is technically impossible, isn't it? However, going by the reasoning in Countess of Dunmore versus Alexander, acceptance by post can be revoked by a faster means. Acceptance by post can be revoked by what? A faster means. Thank you very much.